Hello, everyone. Hello. Hello, hello. Hit that thumbs up. Okay, so we're going to talk about the Sunny Balwani sentence. I put a poll in the chat. I want to know what your vote is. Cast your vote. Do you think Elizabeth Holmes is going to be able to stay home during her appeal? That's her motion for release pending appeal. We'll talk about that too. So I'm going to give you the highlights. So please do hit that like button. Please subscribe if you want to join the chat. And I put a bunch of questions in the chat. So please take a look at that and please do vote. I'm going to check the lighting here. See if I can get it a little better. See if that's better. Okay, so cast your vote. Do you think she's going to be able to stay home during her appeal? And do you think Sunny Balwani got a fair sentence? And put your questions in the chat. Okay, so I'm going to go ahead and get started. So in case you don't know me, I'm Michele Hagan. I'm a legal analyst and I'm an attorney. I also watched the Elizabeth Holmes trial and I provided a lot of legal analysis on the Elizabeth Holmes trial, Sunny Balwani's trial, posted a bunch of videos on a lot of different cases that are going on right now. So it's pretty interesting time, at least for me. You know me, I'm a law geek, so I like following these cases. I guess it's my version of football. So anyway, go ahead and vote in that poll. What do you think? Do you think the judge is going to grant it? Her request to stay home instead of going to prison. So I'm going to give you my analysis. We're going to go over highlights of some of the sentencing and why I think Sunny Balwani got a longer sentence. And secondly, I'm going to answer your questions. So thank you to all of those of you who have submitted questions. I appreciate it. And also thank you to all of those of you who have been longtime subscribers of this channel. I appreciate all your support. And please do subscribe. Please support my work by subscribing. And if you want to send me a super chat, contribute to me making these videos, or for this live analysis, I put a link in the chat box, and also there will be a link in the description box below the video. Okay. Roberto, thank you very much for joining me. She may be granted to stay, but she shouldn't. I'll tell you, I don't think she's going to get it granted. I don't think the judge is going to grant her request, and I'll tell you why, but I'll get to that. So please do hit that like button. Please subscribe if you want to join our chat. Please post your questions in the chat and do vote in that poll. Okay, so in case you popped on this channel, Sunny Balwani was the co-defendant of Elizabeth Holmes. He was charged with 12 counts of wire fraud for basically making misrepresentations about the technology, the financial stability of Theranos, a blood testing company that Elizabeth Holmes started. He was the COO. Elizabeth Holmes was the CEO. He was convicted on all 12 counts. Elizabeth Holmes, was convicted on 4 counts. She was not convicted on the patient counts. There were 4 patient counts. She wasn't convicted on. She was convicted on 3 investor counts and 1 count of conspiring with Sunny Balwani to defraud investors. Sunny Balwani was convicted on all 12, which are 1, conspiring with Elizabeth Holmes to defraud investors, 2nd, conspiracy to defraud patients, and then all 6 of those investor counts Sunny Balwani was convicted of. He was sentenced to 12 years and 11 months. So that's 155 months. Elizabeth Holmes was sentenced to 11 years in prison and 3 months. So why did Sunny Balwani get more time than Elizabeth Holmes? Yes, he was convicted on all counts. But if you've been watching my videos, looking at the federal sentencing guidelines and the past sentences that this judge has imposed on other fraud cases, most judges do not run it consecutively. So each one of these counts would be 20 years in prison. So they don't run it consecutively. So it would be 20 years, 20 years, 20 years. What they do is it's just an incremental increase in the sentence, in the range. So basically, they both ended up at level 33, and you can look at my calculating Elizabeth Holmes sentence videos, and actually the last couple videos I've done on Sunny Balwani, you can take a look at level 33 gives a range of 135 months to 168 months. Both Sunny Balwani and Elizabeth Holmes both got level 33, but she got 135 months. He got 155 months. So it's within the same range, but he got more time. So let's see. I'm going to look at your questions here. I'd like to fund Slicker backdrop. Yeah, I know. Yes, go ahead and fund it. I know. I need a better back. I need a whole setup. What would you presented earlier about this case and the federal guidelines? It seems both Holmes, received a fair sentence. You know what? Rob, I agree. I think they both got a fair sentence. Having watched Elizabeth Holmes' trial, I would say that she got a very fair sentence and a very, very fair outcome of only being convicted on those 4 counts. Because I think, in my opinion, and again, this video is just my opinion, and I want to know what your analysis is, so put it in the chat box or leave a comment when you do watch these videos. But there was a lot of evidence, a lot of evidence that could have supported verdicts on all counts that they found for Sunny Balwani, but also for Elizabeth Holmes. Just my opinion. So, and I think the judge was very fair in his sentencing. Now, neither one of them at this point have told us whether or not they're going to be appealing the sentence, but I'll tell you, I would expect they will be appealing the sentence too as part of their appellate brief. Okay, so let me go ahead and talk to you about, and I'll get to your questions too, so please do post those. Let me just give you some of the highlights of Sunny Balwani's sentencing. So the prosecution said that, the judge needs to consider a significant custodial sentence for Sunny Balwani to send a message to make it a general deterrence for all of Silicon Valley or all the inventors or entrepreneurs out there not to engage in this kind of conduct, a general deterrence. So to send a significant message. Well, the defense attorney said that this is obviously a decision that the judge is making that affects a real human being, and that would be Sunny Balwani. These are statements that the prosecution and the defense made during sentencing. And the defense, Balwani's defense, has always been arguing, as did Holmes, that neither one of them profited. As far as Sunny Balwani, there was no greed factor, there was no financial benefit. But that's not required to convict somebody for fraud. You don't have to profit. The fact is, if you make a misstatement, you lie, you misrepresent, that the technology is accurate, fast, accurate, and reliable, and you take money from people who invest in your company based on those representations, that's wire fraud, and that's what they were convicted of. Okay, so profit, benefiting, that's not required. That's a red herring. And I understand why they're arguing it, but it's not an element of conspiracy, nor is it an element required for wire fraud. And you can also think about, what kind of lifestyle were they living during that time, during the years that they were taking in the money? Are they benefiting or not? I think that can certainly be argued that they did benefit. Okay. The defense also argued that there's no doubt that Ms. Holmes was in charge. She could have fired him. And I think that's an interesting statement. There's no doubt that Ms. Holmes was in charge, because Balwani's defense kept trying to argue that he took a lesser role, therefore he's less culpable and he should get a lower sentence than Elizabeth Holmes. But what's interesting is the defense said she could have fired him. If she could have fired him, how does that play out regarding Elizabeth Holmes claiming she was abused, controlled, and influenced? I think that's interesting, right? Can you fire someone? Think about that for a second. All right. Then the defense also said that Mr. Balwani never wanted to harm anyone. He would never harm a fly. Well, I think the patients would probably disagree with the defense. And I think a lot of people would probably disagree with that statement. When you are someone, and the judge found this, that, the lab was Balwani's baby. Balwani was in charge of that lab. And if you look at the videos I did on the text messages, specifically the one that the judge also indicated in the acquittal motion or the acquittal ruling that he made when Elizabeth Holmes asked to throw out her convictions, the judge said in there the text between Elizabeth Holmes where Balwani says to Holmes the lab was a effing disaster zone and that they were having issues with the reliability, with the employees, etc. Yet they're putting this product out there, this blood testing analyzer out there that people could walk into to Walgreens Wellness Center, unbeknownst to them, believing the marketing, that it's fast, accurate, and reliable. They get a result, and it turns out the result was not correct. And if you look at the video I did, does Tyler Schultz need a math tutor? You can look at the scatter plots that he sent, that email that he sent to Elizabeth Holmes and Sunny Balwani, where he shows how it was unreliable, how the results were not reliable. And Sunny Balwani responded back with, he needs a math tutor. So, okay. The judge said that it's tragic to look at the path of this case and realize that the path has come full circle. The judge also said that Sunny Balwani misled investors and misled patients. So Balwani was given the opportunity, like every defendant, to speak at his sentencing, and he chose not to speak. And there were no victims. There were no victim statements made at the hearing as well. And then Balwani's attorney asked whether or not Balwani could serve time at Lompoc, which is I think it's a medium security prison. It's right near, it's near Santa Barbara in Los Angeles, and I'll talk to you about that in a second. But at this point, the judge is not objecting, so Sunny Balwani may be serving his time at Lompoc State Prison. It's a federal penitentiary. Okay, then at the sentencing, the defense objected to 39 issues that were in the pre-sentence report. And what that indicates to me is the defense was not able. Typically what happens is when you object to a pre-sentence report, you work it out with the probation department. But since they weren't able to come to a compromise or to a resolution, the judge had to make a decision on a lot of those factors. The Balwani defense also asked for the judge to throw out the loss calculation because the higher the amount of loss, the more money that you defraud someone, the more time you're looking at. Okay, so the defense argues that the judge should throw out the loss calculation and they should calculate it as zero. And why did they say that? Because they said to the judge that the loss calculation was speculative and complicated, not for this judge, not for any federal judge who deals with fraud cases and cases involving money. You can do the math, right? We've been doing the math all along. And the judge found the loss calculation approximately is 120 million. And that goes towards restitution. And they're going to have a restitution hearing, both for Sunny Balwani and for Elizabeth Holmes, to determine how much money should be they should pay back to these investors and to the patients. That's a separate hearing. It's called a restitution hearing. It commonly happens after sentencing. That gives both sides an opportunity to file motion to say to the judge, this is how you calculate it, or judge, you should throw out this investor because they were given money in a settlement. That again, that's up to the judge, right, as to what the amount is. And all that's required is has to be a reasonable estimate. It doesn't have to be down to every penny. Okay. So, and if you look at the live analysis I did on the Elizabeth Holmes sentence, I kind of walked you through the math. So if I'm correct about this, and if my math is correct, it looks like the judge also found that there was approximately 384 million was the amount of loss, but then it was offset by the reasonable value of Theranos at the time that the frauds were committed. And so if the judge concluded that it's 120 million, which is the outstanding loss, if you do the math, I think I did that right, it's approximately 264 million, I think, is what they're calculating the reasonable value. In other words, the business value or the business valuation of Theranos at the time the frauds were committed. And so the defense and Holmes asked for the offset for the judge to decrease the amount of loss because of the value of Theranos at the time the frauds were committed. I hope this is making sense. Let's see. Let me look at your comments here. Rob G, the judge wouldn't want problems on appeal if the sentencing seemed excessive. Exactly. Good point, Rob. The judge, as well as, when I was a prosecutor years ago, we have to, whenever you're, criminal cases, or whether you're the prosecutor and even the defense, you also want to have an eye to the appellate record, right? To what record's going to go to the appeal. So you're going to look at the Court of Appeal only looks at the trial transcript, right? So they read through what Dr. Rosendorf testified to, what Erica Chung testified, what exhibits were entered into evidence, right? They read through the whole trial transcript. This is what the appellate court does. So when Elizabeth Holmes and Sunny Balwani file their appeal, they're going to file what's called an opening brief. So they're going to let the Court of Appeal know what are the issues that they're going to be contesting. And I'll get to those 10 issues that Elizabeth Holmes possibly may be appealing because it's in her motion for release pending appeal. So the appellate court are basically readers in a way, right? They look at the words, they read all the transcript, they're looking for error. Did the judge make the wrong ruling on whether or not Balwani's deposition testimony should have came in or been kept out? Whether or not Dr. Doss can testify to the reliability of the technology? Whether or not Dr. Rosendorf's driveway statements warrant a new trial. All of that the Court of Appeal will look at, as well as the opening briefs, the arguments made by both sides, and they're going to look at what the law is. Then they're going to make a written decision, but they could also grant an oral argument for both sides to argue, to present their argument to the Court of Appeal. It's up to the Court of Appeal whether or not they grant oral arguments. After that, they make a written opinion, a written decision on whether or not they're going to affirm her convictions or his convictions, or whether or not they're going to overrule, reverse the rulings or the convictions, tossing the convictions, or maybe they have issues with sentencing. Maybe the Court of Appeal might find this judge didn't calculate the sentencing correctly. I don't think that's going to happen, but we'll see what happens. Okay, so let me get back to what else was going on in the sentencing for Sunny Balwani. So the judge obviously did not throw out the loss calculation. The judge applied the loss calculation. In my opinion, it wasn't speculative and it wasn't complicated. That's my opinion. Then the prosecution wanted an enhancement. Okay, so fraud starts at level 7. Then you add 24 levels for the amount of loss. Okay, so that's level 31. Now, how did the judge get to level 33 for Sunny Balwani? The judge gave a 2-step enhancement because of the number of victims. Same thing that he did with Elizabeth Holmes. She got an enhancement for the number of victims. But what I pointed out to you I think it was the last video I did on Balwani, was a couple of reasons why I think he could get a longer sentence. And one of those reasons was because of, did he create harm, serious bodily injury, or harm to the public? He oversaw the lab. These blood results were going out there that were, based on inaccurate technology, right? So if the judge found that was an aggravating factor by putting people at a greater risk of harm or a serious bodily injury, then the judge could increase it by 2 steps. But the judge didn't do that for Balwani, and he didn't do it for Holmes. Okay, so the judge has to, keep an eye for appeal. Doesn't want to do anything excessive, as Rob pointed out. And he also wants to make sure that it can withstand an appeal, right? This is not the time where judges take risks, okay? They tend to be conservative in a lot of their sentencing and in their decisions. And this judge in particular, he's very conscientious and very cautious. He states what his reasons are when he makes his rulings. It's all on the record. And that will all be reviewed by the Court of Appeal, and they're looking for errors. Did the judge make a mistake in the ruling? Should this evidence have not come in? Should this witness have been cross-examined on bias? That's what the Holmes is arguing in her motion, and I'll get to that in a second. Okay, so hit that like button. Are you guys voting in the poll? Please do cast your vote. Do you think Elizabeth Holmes is going to get home detention, stay at home pending her appeal? Please vote, hit that like button, and do subscribe so you can participate in our lively chat. Okay, Pictor, contradictory arguments. She was under his thumb, but she would have fired him. Well, was she under his thumb or was she not? Who exactly was running the show? Him, her, or both? Okay, the reason I got interested in this case way back when was because I'm a former prosecutor of domestic violence and child abuse, okay? And so I find out that there's this case involving wire fraud, and one of the potential defenses, okay, follow me on this, one of the potential defenses is that Elizabeth Holmes claims that she was abused. She was basically a victim of a, abusive relationship. And I thought, oh, that's interesting. How are you going to get that into a fraud case, right? Well, they never called an expert witness in the Holmes case. The defense never called an expert witness. I'm not aware of any letters by any expert witness regarding domestic violence, or a therapist, or anybody, any experts in the area regarding what are the signs of being in an abusive relationship, how that would impact your judgment, whether or not it impacted Elizabeth Holmes while she was running, Theranos company. So to me, there was no expert to give an opinion on whether or not Elizabeth Holmes was a victim or involved in an abusive relationship. These were all allegations that the defense made. Secondly, I'm not aware of no expert testified at her sentencing, and I'm not aware of any letters by any therapists or experts that indicate that she should have gotten a lesser sentence because she was involved in a domestic violence or an abusive relationship. And you can take a look at the video. I think it's called The Revealing Texts Between Elizabeth Holmes and Sunny Balwani. And you could read through those texts and make a decision for yourself. I mean, this channel is all about thinking for yourself and, forming your own opinions. I'm giving you my analysis. I want to know what yours is. Looking at those texts, the love that they expressed for each other. I mean, you can go ahead and take a look at that video. So, all right, let me see what other questions. Jose said Elizabeth can have another pregnancy begin before. Yeah, everyone keeps bringing up this pregnancy stuff. It is not, I understand it plays well in the media, but you know what? She's not benefiting from it, okay? And pregnancy alone is not a factor in mitigation and sentencing. The issue is whether or not her or any parent is an irreplaceable caretaker. That's the question. Are you an irreplaceable caretaker? And because she has a partner, the father of these children, that argument's not going to work. And, pregnant women, new mothers, and new fathers are sentenced to prison all the time. It's not a factor in mitigation unless you can prove that it's a loss, that you're an irreplaceable caretaker, which doesn't look like it was shown, right? She didn't get any mitigation for that. All right. So good question, though. Thank you, Jose. So Sunny says, why didn't the prosecution ask her for those things? I think it's insane they let her say that and nobody challenged her on it. Well, are you, Sammy, Jose, don't get her started on that. Oh, that's hilarious. Sammy, are you referring to, there was some evidence at trial. There was some text or some notes that Elizabeth Holmes put on her phone, indicating that she something about I'm trying to remember what it was about, but it wasn't really clear. It was something about the interaction between the two of them, and how she felt like she let Sunny down or whatever it was. But I mean, I took a look at it, and to me, it wasn't clear as to what it was referring to. And, they had an opportunity to put on more evidence if they wanted to, and they didn't do it at trial and they didn't do it at sentencing that I'm aware of. Okay, so Sammy says told you. Okay, so let me see what else we got here. Okay, so Sunny Balwani, here's my thinking on this. The reason I think the judge gave Sunny Balwani more time, 20 more months than Elizabeth Holmes, is because he was in charge of the lab. The judge made a statement regarding the lab was Sunny Balwani's baby. The judge had made some statements in his acquittal ruling, which, words matter, and it's important to read these rulings. When the judge found that Elizabeth Holmes and Sunny Balwani worked together, conspired, and lied, that indicates to me that the judge, the sentence was going to be very substantial. So I think because Sunny Balwani oversaw the lab, and because Sunny Balwani was the one who was working out the deal with the Walgreens Wellness Centers, and because Sunny Balwani was the one who did the financial models that were presented to the investors, I think that's why he got more time. It wasn't because, it could be, you could consider that because he was convicted on all counts. The judge definitely had latitude to give him more time for that. But I think those underlying factors were also very, very telling and probably very persuasive to the judge. So 155 months for Sunny Balwani and 135 months for Elizabeth Holmes. He is supposed to be surrendering to prison, and we're going to talk about which one. He's supposed to be surrendering, I think it's March 15th, and then Elizabeth Holmes is April 27th. Okay, so I thought I would tell you some interesting things about Lompoc. So Lompoc's in California. It is a prison that has, it's a medium security prison, and then it has a satellite prison camp. So I did an earlier video where I was looking at the federal prison camps, because that's where Elizabeth Holmes is apparently going to, the one in Texas. That's what I think the judges recommended, the Bryan, Texas facility. You can go to the Bureau of Prisons website. You can find out all about that prison. But Sunny Balwani is going to what's called a federal corrections complex, which combines not only a medium security prison that has all the fencing, it's like a typical prison you can think of, and then it has what's called satellite prison camps. And the one in Lompoc, which is about 175 miles, it's 175 miles northwest of LA. It's about 55 miles northwest of Santa Barbara, kind of a nice location, but it's still a medium security prison. It has two prison camps. There's the North Camp and the South Camp, and it's open housing. It's like dorm style housing, and it's pretty minimal, I would say minimal furnishings, but they don't have the perimeter fencing that you would have at a medium security. It's what's called a minimum security prison camp. Okay. So that's the one that the defense is asking that Sunny Balwani be sent to. The judge is not objecting. So that sounds to me like the judge is going to recommend that Sunny Balwani be sent to Lompoc. So guess what famous prior felons have served time at Lompoc? Well, the White House Chief of Staff, H.R. Haldeman, went to Lompoc for 18 months regarding the Watergate scandal. The co-founder of Earthlink, Reed Slatkin, also went to Lompoc for 14 years. He served. And guess who's currently at that same prison? Currently, this is all according to Wikipedia. I don't have a bat phone to the prison, but according to Wikipedia, there's Henry Jones, and some of you might remember this. Henry Jones was a former record company executive. He was convicted in 2008 mail fraud and a Ponzi scheme where he defrauded apparently 500 investors of over 32 million. And it was also part of the CNBC American Greed series. It's Henry Jones. You might want to look that up. He's currently serving time at Lompoc. These could be, people that Sunny Balwani runs into. There's also Chi Mak. He's a former engineer with Boeing. He's also serving time at Lompoc currently. He was convicted in 2007 of conspiracy to commit economic espionage related to the U.S. Space Shuttle and the Delta IV rocket. He's serving a 24-year sentence at Lompoc. So very interesting. And I thought you also might be interested on, I looked at some other stats here. Guess what percentage of inmates are in the federal system that are serving time for fraud? 4.6% of the inmates. There's approximately 159,000 prisoners in the federal system. 7% are women, 93% are men. The average age is 31 to 41 years old. 45% of those people incarcerated in federal prison, 45% is due to drug offenses, 21% weapons, 3.2% homicide, 4% immigration, and 4.6% fraud, extortion, and bribery. So I thought that was kind of interesting. 26% are there for 5 to 10 years. 23% are serving a time, which is where they are. 23% are 10 to 15 years. So pretty interesting. Okay, so what questions? Any other questions? Sunny was also CFO. Oh, that's interesting. Good comment there, Sammy. All right, so we'll see what happens in the restitution hearing. That'll probably be set sometime soon for both Holmes and Balwani. We'll figure out how much they're going to be paying back the investors and the patients. They're also both sentenced to 3 years supervised release. It's not parole. They don't call it parole anymore. It's called supervised release. Okay. That means once they get out of prison, they have 3 years where they're going to be monitored, supervised. So they're going to be conditions on release. They're going to have to report to the U.S. probation officer, whoever they're assigned, for 3 years after they get out of prison. Okay. So, any questions? Okay, any questions, anybody? Okay, hit that like button. Do subscribe, support my work, and if you want to contribute to me making these videos, there's a PayPal link in the chat box, and there'll be one in the description box below the video. Okay, so what did the defense say after Sunny Balwani was sentenced to 12 years, 11 months? The defense attorney said, "I respectfully disagree with the result in this case. We're disappointed in the outcome, and we plan to appeal and keep fighting for our client, Mr. Balwani." Now, that's classically what, defense attorneys say all the time when they lose cases, but that tells me they're definitely going to appeal. So Balwani's going to appeal too. And probably similar issues. A lot of this might be similar issues. We'll have to see. Okay, so Jose says, thank you for the answer. Oh, you're welcome, Jose. Okay, so let's talk about Elizabeth Holmes's motion for release pending appeal. So in other words, she doesn't want to be in prison while she awaits the appeal decision from the appellate court. She wants to be able to stay at home, stay out of prison, and await whatever decision the appellate court decides. So this is at the judge's discretion, okay? So the judge is going to decide whether or not these 4 factors apply to Elizabeth Holmes to grant her request to be released, to be home, basically, while the appeal is pending. So the 4 factors are, and you guys can tell me what you think of these 4 factors. Number 1, is she a flight risk? Okay. Has she shown up for her court appearances? Does she have any strong community ties? Well, so the judge has to make a determination, and the court may release a defendant pending appeal. May. That means it's discretionary. The judge can say no outright. But these 4 factors is what the Holmes defense is saying should be persuasive to the judge. Number 1, is she a flight risk? And does she pose a danger to the community? Number 2, the appeal is not for purpose of delay. Number 3, the appeal will raise a substantial question of law or fact. In other words, did the judge make the wrong rulings? Okay, and I'll flesh this out a little bit more. And the fourth is the appeal likely to result in a new trial? Okay, so number one, so I'm going to go through these four factors, and then we're going to do a brief look at the 10 issues that she may be appealing. Okay, that may be part of her appeal that she files with the Court of Appeal. Okay, so Sammy says, my feed is frozen. Thanks for your excellent show. Thank you, Sammy. Okay, so let's talk about issue of flight risk. Okay, she's shown up on all her court appearances. The court has allowed her to stay out pending her sentence, right? Because she was convicted back in January. She wasn't sentenced until just recently, right? That whole time she's been out. She hasn't fled anywhere. She's surrendered her passport. She's currently pregnant, right? So strong. So they're arguing, and it's because she's pregnant and has a young son, and she has strong support from her family, that incentivizes her not to flee the jurisdiction. Okay. And also, they pointed out that her parents' home, their only home, is what's securing her bond, her $500,000 bond, so that she could stay out of custody while she was awaiting sentencing. Okay. So that would put her parents' home at risk. That would put her family at risk if she decides to flee, right? So they're arguing not a flight risk. Okay, we got that. The other part of this that's interesting, and these are one or two of the things that I think they may not have met these factors. Two of the factors, and I'll give you one of them, I think she hasn't met, or could be argued that she can't meet, is does she pose a danger to the community? Well, I think Erica Chung and maybe Tyler Schultz would have something to say about that. The defense argues that she hasn't been violent, that the government has never said she's violent or a risk. But also, if you look at the sentencing memo, the video I did on the sentencing memo of the prosecution, where they're asking for 15 years for Elizabeth Holmes, they pointed out under the deterrence that she needs to be further deterred because she apparently is working on some chemical patents. So I don't know if that could be argued as a danger to the community. I don't know. You guys tell me. All right. So Nija, bottom line, what we want to know is based on your judgment. Do you think she will be allowed to stay free? No, I think I said that up front. No, I don't think the judge is going to grant this request. I don't. But things have happened in this case. Okay. So the other question is, and thanks for that question. All right. Let's go to the second factor. Second factor is, I want to share this information with you guys too. I mean, I don't want to race to the end. I want you guys to think about this. Is about analysis. We're analyzing. So here's the second factor. The appeal is not for purposes of delay. Well, I think the prosecution is going to argue, yes, it is. Okay, and I'm sure many of you think it is, that this motion, although like any defendant, this motion is commonly made. When someone's awaiting prison, they can make a motion asking the judge, you know what, we're going to file appeal. Can we have our client stay out pending the appellate decision? What's also interesting, and there's only 2 sentences under this, right? So they don't have much to argue to say that they're saying that because she has valid appeal issues, that it's a legitimate request. It's not for purposes of delay. Okay, third factor, and this is the factor I think that's also she may not be able to meet. This is, will Elizabeth Holmes's appeal raise substantial questions of law and fact? So substantial questions are those that are fairly debatable or doubtful. In other words, were the judge's rulings debatable? Whether or not certain evidence was allowed in or kept out. The substantial question does not require that the district court, that the judge, find that he committed reversible error. So that's up to the appellate court to decide. The question is whether or not the judge's rulings were debatable, okay? The other thing, as I pointed out to you guys many times, words matter. And so when the standard is whether or not, I have to flip back here a second. The appeal will raise a substantial question. The appeal will raise. But in this motion, they keep using the word may raise. Will you go to the store? Or I will go to the store, or I may go to the store. Do you see the difference? I will appeal. I may appeal. Well, the standard, the third factor, requires that the appeal will raise. But in this motion, they're saying she may raise these 10 issues. So was will and may the same to you guys? It's not to me. Okay, I don't think you can say may. She's reviewing the record. And I'll tell you what they said right here. Ms. Holmes' review of the record is ongoing. This is on page, I think it's page 4. It's page 9 of 21 pages. I'm only referring to several here. They said Ms. Holmes review of the record is ongoing. Ms. Holmes has identified the following as among the issues she may present on appeal. Ms. Holmes will likely narrow these issues by the time of the appeal briefing and reserves the right to raise additional issues, including issues related to sentencing. Ms. Holmes, Ms. Holmes, Ms. Holmes. I told you guys all along she's the quarterback. Okay? She may present on appeal. So then they go off to, on many, several pages here, citing these 10 issues that she may raise. Okay? So I understand that they're presenting this to the judge because they want to raise some substantial questions of law. But it's will she raise it? In this motion, they're saying she may. So I don't know if that meets the burden. We'll have to see what the prosecution says in their response to this motion. Okay, so stay with me here. I'll try to go through this quickly. When does Sunny go to prison? He's supposed to surrender March 16th, I think it is. No, March 15th. March 15th, and it may be in Lompoc, California, which is right near Santa Barbara. It's in Santa Barbara County. 55 miles northwest of Santa Barbara. Okay, so getting to the 10 issues. Quickly, I'll go through this because I think I'll probably, once the prosecution files their response to these, we'll be able to talk about this or analyze it a little bit more. So number 1, Dr. Doss. Remember, he was the lab director that was the last lab director of Theranos that was hired after the audit, the CMS audit. He was the one who testified at trial. He checked out the technology. And they argue, and the defense also, the prosecution called him to talk about the voiding of all the lab results, the voiding of the tests. The defense is arguing that this may be an appeal issue, is that Dr. Doss was testified, they're arguing, as an expert witness, not as a fact witness. Now, I know this gets all technical, but bottom line is what they're arguing is what Dr. Doss testified to. His testimony should be thrown out because he wasn't qualified as an expert, okay, to talk about the standard deviation of the test, the quality control values. I'm sure the prosecution is going to argue, no, he testified as a fact witness based on what his experience was with the technology, what he saw when he was looking at the technology and the results. He's entitled to testify to that. Again, this is up to the judge, and the appellate court's going to have to find that the judge made the wrong ruling here. Should not have let this Dr. Doss testify or testify to this quality control issues or the standard deviations, okay? The Court of Appeal has to find that the judge abused his discretion. He made the wrong decision. I don't think that's going to happen here. Okay, so let's get to the next issue. The next issue is the CMS findings. The Center for Medicare Services did an audit of the Theranos lab, right, that Sunny Balwani was overseeing, and they found there were a lot of issues. I mean, it was subsequently shut down, but they found several issues, and they also issued sanctions against Theranos. Now, that evidence came in regarding the CMS sanctions, and some of the excerpts from the CMS report when they did their audit, that was allowed in as evidence in the Holmes trial. Holmes is arguing that's an appealable issue because it didn't go, they're arguing it didn't go to her state of mind. In other words, what did she know? What was her knowledge about what was going on in the lab in order to evaluate whether or not her representations to investors were truthful or not? Okay, so Holmes is arguing that it's not relevant and it didn't go to her state of mind. Therefore, the CMS evidence regarding the sanctions and the findings should not have been allowed into evidence. I don't think that's going to work either, but we'll see. We'll see what the prosecution has to say. And they also said that the voiding of the results of those, in 2016, they voided all the results of blood tests. The defense said it confused the jury's assessment of Ms. Holmes' intent and state of mind and substantially prejudiced Ms. Holmes on the core issue of the case, which was the accuracy and reliability of Theranos technology. Well, how can you say it confused the jury? Did you interview the jury? Isn't that speculation? I understand what they're doing, trying to do here, but you're speculating. We don't know how the jury made their decision. Did it substantially prejudice? Well, any evidence that prejudices or shows that incriminates your client, you can always argue prejudices your client. Okay, that's not really the test. The test is, did the judge make the wrong ruling, and is that ruling debatable? I don't think so. Okay, let's get to the third issue, the voiding of the tests. They had a bunch of motions in limine, which are called motions in limine. No, it's motions in limine. These are motions you have prior to trial to determine whether or not to get a ruling from the judge, to determine whether or not certain evidence comes in or stays out, whether or not certain witnesses can testify or not. Okay, so you can figure out how to plan your case, right? If you get these kind of pretrial rulings. So there were a lot of motions made, and the defense makes a big deal about how complicated this, and it was a hard-fought case, and it took 4 months to try it. Like, that's, I understand what they're doing, but there's many trials that go a lot longer than 4 months. Many trials that have more than 30. What did they have? 36 witnesses. This wasn't that big of a deal, in my opinion. Okay, but I've tried a lot of cases. Okay, but I guess for them, it was a complicated, hard-fought. The trials are hard-fought. They are, but I don't think this case was that complicated. I don't. All right. So again, just my opinion, and all due respect to all counsel. Okay. So all right. So whether or not the Edison test should have been, that whole testimony should have been allowed in or out, the judge allowed it in. The defense said it was prejudicial, and the judge should have limited it to her state of mind. In other words, they shouldn't have considered it. The jury should not have considered it for any other reason. I don't think that's going to be very persuasive to the Court of Appeal. I don't know. Okay, number 4. So how are we doing on any questions, or are you guys following me? All right, number 4 is this gets to the LIS database. The database that allegedly contained all the results of all the testing that Theranos did. That database was not presented at evidence in trial, neither trial, because the database has been basically destroyed. All right. And the access code that was apparently given, the Balwani and Holmes provided an access code to the database, I'm back messing this up. It's Friday. All right. the government was never given the access code to this database. So they were never able to find out what was in the database. But what the defense, Holmes's defense, is arguing is that the government violated Brady. And Brady requires prosecutors, the government, to turn over any evidence that's exculpatory and inculpatory, incriminating or not incriminating, against the defendant. And if you don't do that, then the Court of Appeal can toss out convictions. Judges can toss out cases if you violate Brady. But what they're relying on is two cases: United States versus Loud Hawk, for those of you law students and lawyers that are following me, and Arizona versus Youngblood. And they're saying that if Holmes' defense is saying that the prosecution failed to preserve the database because several months went by, and Holmes found out after the conviction, I think it was after the conviction, that there were emails between the prosecution and a expert. I'll call him a database expert or a security expert, who was able to say that there was a way to preserve the database. This is what they're all alleging, to preserve the database. And because the prosecution didn't preserve it, that Elizabeth Holmes was prejudiced, right? That they were not allowed to be able to use that evidence to, I guess, say that she was not guilty of this, right? Because that ultimately that database would show whether or not the technology was accurate. All right, so Holmes argues that in the pretrial suppression ruling, the court erred in holding that the government did not act in bad faith. One of the motions for a new trial was based on the government, they're kind of rehashing a lot of these issues based on the government not preserving the database. And the judge found that didn't warrant a new trial, didn't grant them a new trial hearing. And the thing is about whenever there's any kind of Brady violations, the defense has to show that the government acted in bad faith. So what evidence is there that the prosecution acted in bad faith? Is it the fact that they were apparently the same prosecutors involved in those emails that were the ones that tried Elizabeth Holmes? Is that acting in bad faith? No, usually in my opinion, it's not, but bad faith has to be something that they did was unscrupulous or something where they ended up destroying the evidence. And keep in mind, they were not given the access code to the database. So we don't know what the evidence is. They weren't able to look at what was in there to find out whether or not it was incriminating or not. Is that alone bad faith? I don't know. We'll have to see what the Court of Appeal does, but this judge did not find, right? There was no hearing granted on whether or not the judge should find out whether or not the prosecutors act in bad faith. The judge already ruled, right? So, and they bring up the fact that Holmes had requested an evidentiary hearing to find out what happened. The judge denied it. Okay. So, again, the Court of Appeal can make their own decision. The other thing is, during the trial, the defense could have called an expert to talk about, maybe they could have presented that. Maybe they brought it up in the pretrial motions. I don't think so, but, again, it's up to them to decide how to try this case. So I don't know about this database, but I'll tell you this: whenever there's Brady violations or violations of a defendant's right to confront witnesses, which is a constitutional right in the Fifth Amendment, whenever constitutional issues come up for a Court of Appeal, that can be problematic for the prosecution. Okay, but I don't think at this point that these are legit. These are, these are issues that will require the court to revert. The court to grant. To consider these as legitimate appeal issues. I mean, I understand they're raising them, but I don't think that they're going to be persuasive enough because I don't know how they're going to meet that bad faith test. How are they going to show the government acted in bad faith? It's one thing if the government had opened up the database, knew what was in it, and didn't turn over the database. or I'm trying to think of another example. But in this case, they didn't even have access to it. And the reason they didn't have access to it is because Theranos didn't provide them with the access code. So who knows what was in the database? All right. Do you see my point? We don't even know if it was really evidence. Okay. But the defense says, that's a Brady violation and the court should take a look at it. All right. Number 5, Balwani's testimony. There was an SEC lawsuit, I'll call it an SEC lawsuit, where Balwani was deposed. And in that deposition, he talked about his role at Theranos, that he was in control of the financial models and stuff. Well, the defense wanted to get that in to show, because they wanted to shift the blame to Balwani regarding the financials. So the court was, only let in certain evidence, but the defense is saying that because the court excluded the deposition of Balwani, Elizabeth Holmes was prejudiced. The judge made the wrong call, is what they're arguing. So we'll have to see how far that goes. Okay, let me see your question here. So, Mitchie, love your channel. Thank you, Mitchie. Thank you for the best coverage on this case. Thank you. Jay Randy, it seems that the prosecutor and the court have been very careful and limited in these cases. I think that the appeals will not have much traction. Yeah, well, good point, Randy. I think this judge has been very considerate and very cautious. And in my opinion, this is a good judge. Okay. And I've tried cases in many different jurisdictions. He was very patient to both sides. He was very considerate of both sides. He stated his rulings. Okay, think of this. Elizabeth Holmes got a hearing regarding the new trial, right? She wanted a new trial because of those statements that Adam Rosendorf made in the driveway to Billy Evans. Do you remember that? She was granted, you can look at the video I did. She was granted a new trial hearing. Allegedly Rosendorf made the statement, the prosecutor made things seem worse than they were. He shows up at the driveway, he wants to talk to Elizabeth. He makes these statements that the defense says, after Elizabeth is convicted, hey, judge, we need a new trial here because a very important witness here for the prosecution. It seems like, he's changing his testimony. I'm paraphrasing. He's changing his testimony. He was a very crucial witness. Therefore, we need to have a new trial here. You need to throw it out. You need to, grant us a hearing. And the judge granted a hearing. I think a lot of judges would not have granted that hearing. Okay. So Adam Rosendorf got back on the stand. He testified as to what happened. He didn't deny he made the statements, but he also said he didn't lie in his testimony. I'm paraphrasing. He didn't lie. He didn't change his testimony. So they didn't meet their burden there. The judge denied her request for a new trial, but this is going to be an appeal issue too. Okay. So what happened in the driveway, are those statements show that Adam Rosendorf, this is number 6, limiting Adam Rosendorf's cross-examination. Actually, hang on for that second. I'll go back to the driveway in a second. Let me go to number 6. So the limitations on the cross-examination of Dr. Rosendorf. So the defense is arguing they weren't able to ask all the questions they wanted to ask of Adam Rosendorf in cross-examination. And they wanted to get to ask Rosendorf about his bias, because one of the things that we're allowed to do is we're allowed to cross-examine a witness based on any motive, bias, any reason we can just, how do I say this? Whether or not they have a bias in the outcome, whether or not they have a motive to lie, whether or not they have any prior inconsistent statements, anything that's impeachable, all of that we're allowed to ask. And so the defense is saying because they were not allowed to ask Rosendorf about his post-employment at 3 other labs that were apparently being investigated. This is after he left Theranos. The judge didn't allow the defense to get into all of it. The judge did allow some questions, but the defense is now arguing in this motion that they weren't allowed to ask additional questions regarding his employment at Perker Elman, Invitae, and Bayonne. 3 labs that Rosendorf worked at after Theranos, and that were being investigated, apparently investigated, or something to do with their labs where they were being investigated. The defense wanted to bring it in to show, I guess, basically that Rosendorf is a knucklehead and he went to other labs and he screwed those labs up too. I guess that's what they're trying to argue. But the judge didn't allow them to get into the, additional questions. So they're arguing because of that, they weren't able to point out to the jury that Rosendorf had, has a bias, he's basically a knucklehead, and that the jury should have been told about this, that his other labs were being investigated. Therefore, they weren't allowed to get into bias testimony. Now, I don't think that's really going to work, but we'll have to see. And they're bringing up the confrontational clause, the right to confront witnesses against you. And the Fifth Amendment, I hope I'm right about that. Every defendant has the right to confront witnesses against you. So if you know that a witness, let's say, was a sloppy lab director or was a knucklehead in subsequent labs, could that mean that he's really the problem here and it has nothing to do with the technology of Theranos? I don't know. And again, it boils down to, did this judge make the wrong call? And the other thing is, the judge has to balance whether it's probative versus prejudicial. And so you law students out there know what I'm talking about, and you lawyers. So probative means it has to have some value to the jury, okay? So is it valuable to a jury to know that he worked in these 3 other labs and these 3 other labs were investigated? Or is it too prejudicial? Or is it prejudicial against Rosendorf to point out, that he worked at these other labs? The judge found that it wasn't probative enough. It wasn't meaningful enough to talk about what happened later, because what's really relevant, I'm sure, is what was argued by the prosecution, and I think that's what they argued, was really relevant is what happened when Rosendorf was at Theranos. Because you don't know what's going on at those other labs. The jury wants to know what happened at Theranos. Was the technology accurate, right? What was going on in the labs? And Adam Rosendorf, as lab director, testified to what was happening. So did Erica Chung. So did Tyler Schultz. Okay, so I don't know if that's going to be successful. And again, I'm kind of not giving my full analysis here because I haven't seen what the prosecution has said yet. We have to see what their reply is going to be. Okay, so what about the new trial, the driveway statements by Rosendorf? This is number 7 of 10. So the defense is arguing, Holmes' defense is arguing that those statements made by Rosendorf, because the judge said it was so, the court felt compelled to hold a evidentiary hearing because they were troubled by the statements, or because it doesn't really happen where a witness goes and contacts the defendant. Well, it's happened in my cases. When you're dealing with family members and friends of friends, they tend to contact each other again. But anyway, so Dr. Rosendorf's post-trial statements in the driveway, the court said it was unprecedented, right? And they said the event was so troubling that the court felt compelled to hold an evidentiary hearing. Well, actually, the defense asked for the evidentiary hearing. And luckily, the judge granted them the evidentiary hearing to bring Rosendorf in to find out what happened, because the judge wanted to make sure the record was clear, because he, I'm sure, knows that it was going to be appealed, right? Most defendants appeal their convictions. So, the judge wanted to find out, okay, let's see what Rosendorf has to say. Let's bring him in. Let's see what happened. Is he going to say now that he's changing his testimony, that he lied on the stand? No, he didn't say that. So the judge, carefully laid the record for what happened in the driveway, whether or not Rosendorf is changing his testimony. And the judge found that Rosendorf is not saying, judge found that Rosendorf wasn't changing his testimony. Okay, so her motion for a new trial was denied. So, but they're bringing it up again for potentially, it may be brought up to the Court of Appeal. Then they get into the fact that the prosecution was cherry picking evidence. which I think is, an interesting statement. I guess a lot of criminal defense attorneys are using that phrase, cherry picking evidence. Well, as a defense attorney and as a former prosecutor, we put on cases as we, whatever witnesses or evidence we think can prove each one of the elements. So if you want to call that cherry picking, go ahead. But, it can also be said that the other side, the opponent, is also cherry picking when they put their case on. Okay. So, but I understand what they're doing here. Let's see. And again, they bring up, the driveway statements undermine the credibility of Rosendorf. Well, I think that new trial hearing showed that it didn't undermine the credibility of Rosendorf. And they say a jury in a new trial would probably acquit Ms. Holmes if it had heard an important government witness testify that he took extraordinary step of going to her home. Well, okay, put Rosendorf's testimony aside. You still have Erica Chung, all the witnesses who testify what was going on in the lab and with the technology. You still have Tyler Schultz. There's plenty of other evidence that the Court of Appeal can rely on to justify or to substantiate these convictions, okay? But, that's assuming they find that Rosendorf lied or changed his testimony, which I don't think we have evidence of that. Okay, number 8. We're almost there. Number 8. The court admitting the evidence regarding the alleged misrepresentations to the Department of Defense. There was all this testimony in the Holmes trial about how, Elizabeth Holmes made representations that they were working with the Department of Defense to put the technology in medevac or to put it out in the battlefield, right? Do you remember all that testimony? Okay, let me look at the questions here. Why was Elizabeth Holmes and Sunny held in contempt for not providing why were they not held in contempt? I don't know about that one. That's a very good question. I think probably it may not be a clear path to them, if you know what I mean. I don't know. I don't know. You'd have to ask the prosecutors that question, but it's a good question. Elizabeth Holmes should have received more time for affecting patients' lives. Can't believe the jury didn't convict her. Well, on the patient counts, I think, in my opinion, there was evidence there to convict her. Sometimes juries reach a compromise. Okay, Elizabeth Holmes took the stand. Maybe some of the jurors felt that maybe she should get some credit for that because she subjected herself to 7 days of, testifying, several days of cross-examination, even though I didn't really see her take in my opinion, I didn't see her take responsibility for what happened or potentially could have happened. CEOs do it every day where products screw up. I didn't see her show, in my opinion, remorse or taking responsibility. She did admit to the logos, though. Maybe the verdict was a compromise. Maybe it wasn't argued. Maybe the jury didn't clearly see the evidence. This evidence relates to the patient counts. Maybe it wasn't argued as clearly. In closing, you guys make the call on that. But I do think there was definitely evidence to convict. Aaron Tompkins testified. I'm trying to remember the physician assistant that also testified regarding the patient counts, regarding the false prostate cancer, the false miscarriage results. I mean, it was pretty compelling testimony. I just don't know if it was argued enough. Okay? All due respect to counsel. So the database copy couldn't be accessed. Yes, Rob. Theranos deleted the original. Yes. Data from Arizona tests would likely show high failure rate, but since nobody now has access, it's a red herring for the defense. That's a good point, Rob. But, as I said, if the appellate court finds that it's evidence and that it potentially could have been exculpatory, meaning not incriminating towards Elizabeth Holmes, evidence that was withheld from a defendant, appellate court could toss out the convictions. Now, the other thing is they have to still find that there was bad faith on behalf of the government. And also, we don't know what the evidence was in the database because neither side was able, the government clearly was not able to access the database. So we don't know if it was actually evidence that was helpful or not. Okay. That to me is a speculative argument. Although, Brady violations and when you withhold evidence, courts take that very seriously. I don't know if it's been fleshed out enough to be a valid and a winning appeal issue, but that's a good question. Okay, so if Sunny's trial was first, do you think he would have had a lighter sentence? If Sunny's trial was first, do I think he would have had a lighter sentence? No, I don't think so. There was a lot of strategy involved. I'll leave it at that. Okay. So, all right. So, number 8, regarding the Department of Defense misrepresentations that the defense is saying, and the representations that Elizabeth Holmes supposedly made to these investors. And when Dan Edlin testified regarding the statements made to the Department of Defense, or the misstatements made, that was part of the evidence that came in the Holmes trial. Well, the defense is arguing here that the government offered no coherent theory for why alleged misrepresentations made by the Department of Defense was part of their scheme, their fraud scheme, okay? And it left the jury with the impression that those misrepresentations were made to the investors. Well, and they're also saying it's classic propensatory evidence, basically saying that character for misrepresenting, or if she lied here, she lied there, is the allegation. But the problem with that is you can argue that in closing. Could you have argued? I mean, I don't know. I don't remember them arguing that in closing. And there was a lot to cover in this case. So, and maybe it wasn't apparent at the time. I don't know. But, that's up to the jury to decide and to evaluate the evidence. And, were objections made when Dan Edlin testified to all of that? I don't recall, but maybe there were. Let me see. Did they put it in their motion? No, it doesn't say that they did or didn't. And they're saying that those misstatements regarding the Department of Defense were made a year and a half before the investors invested. Therefore, how would the investors know? But Dan Edlin testified to that at trial. So, the way to keep out evidence at trial is you object or you do a motion prior to trial. And if things happen, you argue it in closing. So, again, I don't remember every single moment of that trial. So I'll leave that to you. All right. So let me see. Any other questions? I got 2 more to go. Under Sox Law senior level, okay, management is responsible to safe keep database encryption's key. Yeah. Yeah. I mean, I think there was testimony that Balwani was involved in encrypting the database. They could know. Yeah. Setting a bad precedent for other execs. Well, it happens more often than you think that people destroy evidence, right? When they're being investigated. So, okay. Michelle, your analysis has been through. Based on your observations during trial, do you feel the evidence was very damning? Based on that, should it be tough? I think the evidence was very compelling. I think the evidence was very persuasive at trial. Thanks for your question. I think, in my opinion, Holmes was lucky. She was only convicted of 4. And, I just want to remind you, Balwani didn't have to take the stand. We have defendants. We all have a right not to take the stand, right? We have the right to remain silent, the 5th Amendment. And if a defendant does not take the stand, the judge cannot punish you for that, cannot increase your sentence. But if Balwani had taken the stand, taken responsibility, cooperated with the prosecution, those are all mitigating factors. But that didn't happen, okay? So just to remind you of that. All right, let me get to number 9 here. Denial of the new trial motion that Elizabeth Holmes made based on the government's closing argument in the Balwani trial. Ms. Holmes may raise, here we go again, may raise on appeal the court's denial of her motion for a new trial based on the government's closing argument in Mr. Balwani's trial, because they're claiming it was newly discovered, having watched or seen Balwani's trial. They're arguing that because in Balwani's trial, they characterized the relationship differently between Balwani and Holmes than they did in the Holmes trial. In the Holmes trial, the prosecution portrayed the relationship as Balwani being, or I should say, as Balwani being an equal partner with Elizabeth Holmes in the Holmes case, right? And Holmes were alleging that Balwani was influencing her, controlling her. He was the one making the calls. The prosecution said, no, equal partners. But when they got the same prosecutors, same judge, different defense team, got to the Balwani trial, the prosecution argued about Balwani's age, his influence, not about the abuse, but his age and his influence and his business experience. In other words, I think the defense is trying to say that he was influencing her. In other words, they changed between the trials how they portrayed the relationship. So they're basically crying foul here, right? And they're saying it's newly discovered because of how the government portrayed it, changed the characterization of the relationship from equal partners to influence by Balwani on Holmes, that was newly discovered evidence, therefore their new trial should have been granted. Well, here's the problem. There's a jury instruction on closing argument where jurors are told that closing arguments, the statements that we make in closing argument, the statements that we make in opening statement are not evidence. Not evidence. It's our opinion. It's our analysis. It's what we're going to tell you the case is about, or what we have just shown you. Why you should find Balwani or Holmes guilty of wire fraud, of conspiracy. So-and-so testified. We met that element, blah, blah, blah. Okay? So they're saying that, let's see, contrary to the court's post-trial ruling, when they did the new trial ruling, the prosecutor's statement and closing argument are admissions of a party opponent. Well, I think that, maybe that's debatable, but there's a jury instruction, and I'm curious to see what the prosecution says to that. But to me, that's not persuasive either. Okay. All right. Number 10, the last one. The denial of the new trial motion based on the government's failure to the government's failure to produce information regarding the database. Ms. Holmes may raise on appeal the court's denial of her new trial motion based on the government's failure under Brady versus Maryland. If you want to look that case up, Brady versus Maryland. It's a 1963 case. They're saying that the government failed to produce exculpatory emails relating to the government's failure to preserve the database. Basically, there were a couple emails that went between the prosecutors, their staff, to figure out how to deal with the database, okay, and to find out whether or not there was a code, access code, and they said that the new emails show that the three prosecutors at counsel table throughout Ms. Holmes' trial failed to take specific steps recommended by expert government personnel to access, collect, and preserve the central repository for patient testing data, the database. For the reasons explained in prior pleadings, the evidence contained in the database would have been central to any full and fair assessment of the government's accuracy and reliability allegations. So, because their emails where the prosecutor reached out to one of their security people to find out what to do about this database, they're saying that the government should have produced those emails to them. And because they didn't, and they found out after the conviction, after the trial, that the judge made a mistake and should have granted them a hearing to determine what happened and should have also granted them. Couldn't they have called the expert? Oops. Did I lose you guys? Maybe they could have called the expert. I don't know. And again, keep in mind, neither side had access to this database. The prosecution didn't have the code. The database was destroyed or not accessible. So again, we don't know what the evidence is. So we don't know whether or not it was helpful or harmful. So that may be a speculative argument. I don't know. And again, they still have to meet the bad faith. They should have to show the government acted in bad faith. And I think emails discussing about the database, the access code, or ways in which maybe it could have been stored, I don't know if that's enough. And again, we'll have to see what the prosecution thinks, but I'll tell you this much. The judge didn't grant the hearing. So, and ruled against them. So we'll see. We'll see if the appellate court or if Elizabeth Holmes makes that one of her appeal issues. And I think that's it. So, it comes down to whether or not any of these questions of law or fact are debatable. Are the judge's rulings debatable? And if they are, that's one of the factors that they have to meet. They have to show not a flight risk, not a danger to community. The appeal is not for purposes of delay. I don't have them all memorized. And the fourth one was whether it's likely to result in a new appeal based on substantive questions of law and fact. In other words, were the judge's rulings debatable? Did the judge really screw up here? Did he abuse his discretion? Was her constitutional rights to confront Rosendorf about whether or not, he had a bias, whether or not he was a knucklehead in other labs? Did the government act inappropriately with the database, failing to preserve it, failing to turn over these emails? The statements that Rosendorf made, did he retract his testimony? Did he recant? I don't know. We'll have to see. So, how are we doing here? Let's see, any questions? By law, the database is required to be encrypted. The data is all there if Sunny would have provided the key. Yeah, that's definitely what a lot of people think. Okay, so your questions, because I want to wrap up here. It's Friday. I'm sure you guys all got stuff to do. So Jackie said, it's too bad Sunny and Elizabeth's money couldn't have been legally frozen at the start, so the money could have been used for restitution before they paid their legal fees. Well, I don't know. Did they pay their legal fees? Dano said, Michelle, could you maybe answer in the upcoming blah, 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 how long Elizabeth Holmes could stretch out her going to prison by the appeal process? Well, my opinion is the judge is not going to grant this motion. In other words, she's going to go to prison. She's surrendering April 27th. Usually what happens when a defendant is facing a substantial amount of prison, they go to prison pending appeal. They're not out pending appeal. If they were sentenced to maybe a year or so, maybe they'll be out pending appeal. And given that the defense has put in this motion these issues and kind of partially fleshed out some of their reasons they may be appealing, I don't know if that's going to be enough for this judge to grant her motion. And I don't know if the judge thinks that she's a danger to the community. I don't know. But those factors have to be met. And again, even if those four factors are met, it's still discretionary as to whether or not the judge grants her the opportunity to stay at home while the appeal is pending. Okay? All right. So let me see. Next question. So Pictor said she will serve time because some or all of her guilty counts will stand after the appeal review. I think a lot of people agree with you. There are serious crimes involving tens of millions, actually hundreds of millions. Therefore, she will be imprisoned on the date assigned by the judge. Well, the date surrendered, which is April 27th. Rock, so thank you for that question. So Rock said, but Balwani wasn't given 15 years as feared by some. I am sure he will appeal. He will definitely appeal, Rock. Thanks for that question. So Ann Diamond, I feel like the judge will tell her that she's looking a gift horse in the mouth and asking to remain out of custody during the appeal process. Again, every defendant has a right to make this motion. Most do. It's a pretty routine motion. The reasons she stated, that's all another issue. He's already bent over backwards accommodating her numerous requests. Well, I don't think anything really out of the ordinary has happened. I mean, yes, I know that media coverage has been exponential. I know because of the characters involved, there's been a lot of coverage. But really, a lot of the motions and the delays and stuff, they're pretty common. And trials take a while. It has been very humane of the judge to allow her to report to prison after the birth of her child. Yeah, as I said, I think the judge is being very compassionate. Okay. One windy old bird said, I thought that being found guilty on so many counts, he would spend more time in prison. You were right. He got more time. But honestly, I thought he and Elizabeth Holmes might get the same time because I see them equally guilty. Well, again, it's a conspiracy, right? Balwani on 2 counts of conspiracy. Well, I think it's because Balwani oversaw the lab. It's what I said earlier. Oversaw the lab. I think those text messages, look at those videos I did, are very incriminating to both of them. Very incriminating. Balwani was keeping her up to speed on what was going on in the lab, the effing disaster zone. He made a comment about he doesn't think this stuff is ever going to work. You can go ahead and look at those texts. And for them to be during that time out there taking money from investors, that's fraud. Okay, and that's what the jury found. All right, let me see if there's any other questions here. Do you guys have any other questions before I sign off? Sammy made a comment about the cross-examination of Rosendorf as being maybe one of the more viable issues on appeal. He said, we're back at this again. The Mea Culpa driveway visit where Rosendorf went to try to talk to Elizabeth after the conviction. Sammy said he caught the interview with Rosendorf, and he comes across as rather twitchy. So maybe they'll roast him again. Well, they're not going to be calling any of the witnesses again. At this stage, it's the appeal. It goes to the appeal next, assuming nothing else happens. The appellate court doesn't take any new witnesses. There's no testimony. They make their decision based on the transcript. What happened at the trial, what evidence was admitted or not admitted, whether or not the judge made any bad calls, made any errors. There isn't any testimony taken. There may be oral argument if the appellate court grants it. Okay, so we'll have to see what happens. And last question, Hugo Burns said, what happens at restitution hearing? Well, they put on the evidence. There's probably going to be, potentially they could put on evidence. They could have the investors come and talk about how much money they lost, or they could maybe submit records. We'll have to see. And he asked, how come they couldn't sort it out at sentencing? Because they don't. That's a whole nother potentially evidentiary, meaning evidence. That's a whole nother hearing that takes place after sentencing. How long it's going to be, I don't know. I think it could be a morning, it could be an afternoon, it could be an all-day thing. But I think the probation department has already taken a run at this, right? Because in the pre-sentence report, although we don't have that because it's confidential, we do know that there was some calculation made, because in both the Holmes sentencing and the Balwani sentencing, the judge calculated the loss at $120 million. So to me, around $120 million. So to me, that looks like that's what the restitution is going to be. Now, I don't know to whom and how much. We'll find that out, and they'll probably be setting a restitution hearing shortly here. We'll have to see. So any other comments or questions? What about the compensation to the victims? Well, Arthur's asking that question. That's the restitution hearing. We'll have to see what the judge decides, who gets paid back what. And they'll have to, it's on the government. Government has to prove those damages, okay? It's not assumed. So there'll have to be some kind of evidence, whether it's reports from the investors, maybe statements made to the probation department. They'll have to make a calculation of what the loss will be, what the amount of restitution. And also, that's an issue that could be appealed. Okay, they can appeal anything they want. Whether or not the Court of Appeal finds it, is persuaded by it to change the convictions or to change the sentence. If you think about the Jeff Schilling case, this CEO of Enron, he was convicted. I think he was sentenced to 24 years initially. Then he appealed, and because there was an error made by the judge in the sentencing, the Court of Appeal sent it back to the trial judge, to resentence. And the government at that point offered a sentence, I think it was 14 years or whatever it was, a shorter sentence, which Schilling took. Okay, so that was an agreement on the sentence. The judge didn't resentence Schilling to it. But anyway, that's part of the strategy here. You always want to test the evidence. Every defendant has a right to appeal. So for whatever reasons, they're arguing, that she may be appealing these 10 issues. I'm sure there's going to be more, and we'll have to see what they put in their opening brief. Okay, I think the opening brief is due March 3rd, I think, if I'm right about that. And then I think the prosecution has a reply sometime thereafter. So, anything else? Any other questions before I sign off? How did we do in the poll here? 91% of you say no, that it's not going to be granted. She's not going to get her home detention. I agree with you. But let's see what the prosecution has to say in their reply. And I want to thank all of you for joining me on a Friday night. I appreciate it. Thank you for all your questions. Thank you for your continued support. Thank you for hitting the like button. Thank you for all of your wonderful questions, your great analysis that you've been making from day one when I started this YouTube channel. Probably the best kept secret on YouTube. But anyway, I'm going to continue to cover this case for as long as I can. And there's a lot of other interesting cases out there, right? That I'd like to dig into too. I mean, there's other frauds out there that are very interesting. So thanks again for watching. Hit that like button. Thank you again to all of you who have subscribed. Please do support my work by subscribing. And thank you for watching.